So you said Ms. Lichter, I believe you said that, okay, Ms. Moran's here, then why don't we, and are you folks ready to proceed?
We are, if Ms. Moran's client is on
I
the
just
Zoom.
emailed her. I don't know where she is.
Got it.
Sorry about that.
That's okay. Ms. Fisher, are you ready to proceed?
Yes, we are, Your Honor.
Okay, then why don't we do that? What's that?
Before we go on the record, may I ask you a question? There is going to, I would like to have the parties identify signatures. I didn't know if you wanted me to do that by share screen or just put the document up to the camera.
Either's fine with me. I'm not smooth enough to do share screen that well. So, but
Okay.
that's okay. You God knows you're welcome to do it.
Okay, well, I'll just do it by putting it up to the camera then. And then one other issue that came up when I was preparing this morning, it appears that on the judgment, on the last page of the judgment, it says respondent is restored to her maiden name of Mia Boydie, and Mia is actually the petitioner.
Okay.
Would you be willing? Thank you.
That correction now. And Ms. Mia Castillo, I'm gonna.
Yes.
And Mr. Mario Castillo Salguero, I'm gonna ask that you please each raise your right hand. And do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Swear.
Please lower your hand. And Ms. Fisher, you are welcome to make a record and proceed.
Thank you, Your Honor. This is in re the marriage of Mia Castillo and Mario Castillo Salguero, number 20D243. My client, Mia Castillo, is here in Zoom court with me, as is the respondent, Mr. Castillo Salguero.
And thank you. The court has those documents. You are welcome to proceed with trial.
All right. Mia, if you could please state your name for the court.
Mia Noel Castillo.
And you reside at 34400 North Circle Drive, Round Lake, Lake County, Illinois.
Yes, I do.
You're 24 years of age.
I am.
You are employed as a shift manager by Starbucks.
Yes.
And you've resided in Illinois for at least 90 days preceding the filing of your petition for dissolution of marriage.
Yes. Yes.
You are currently married to Mario Castillo Salguero.
Yes.
You were married January 11th of 2019.
Yes.
And that marriage is registered in Maricopa County, Arizona.
Correct.
Mr. Castillo Salguero lives at 130 Washington Street, number 1, Ingleside, Lake County, Illinois.
Correct.
And he is also 24 years old. Mia?
Yes.
Okay. You and Mr. Castillo Salguero have lived separate and apart for a continuous period of not less than 6 months.
Yeah.
Irreconcilable differences have caused the irretrievable breakdown of your marriage.
Yes.
Yes.
Efforts at reconciliation have failed.
Yeah.
Yes.
Further attempts at reconciliation would be impracticable and not in the best interests of the family.
Yeah.
No children were born of this marriage.
No.
You never adopted any children,
No.
and you are not now pregnant.
Nope.
No.
You and Mr. Castillo Salguero have signed a marital settlement agreement, correct?
Yes.
Correct.
And if I can direct your attention to page 6 of that agreement, I'm going to try to do this on the camera. Can you see it? Mia?
Yeah.
Is that your signature?
Yes.
And you signed this document, in fact, in my office on Friday, right?
Yep.
You initialed every page other than the page you signed.
Yes.
And before doing that, you had read the document to ensure that it accomplishes your agreement with Mr. Castillo Salguero.
Yes.
This marital settlement agreement divides your assets and debts.
Yep.
You are both waiving all rights to maintenance from the other.
Yes.
And you understand that that means you cannot come back into this court or any court at any time in the future and ask for maintenance from Mr. Salguero.
Yep.
You instructed me not to do discovery in this case.
Yeah.
You felt you had enough knowledge of the marital assets and debts that you did not need it.
Yes.
Are you still comfortable with your knowledge of the marital estate?
Yes.
Is this marital settlement agreement satisfactory to you?
Yes.
Can you live by its terms?
Yep.
Did you agree to it voluntarily?
Yes.
And if the court sees fit to grant this judgment of dissolution of marriage, you want the marital settlement agreement incorporated in that judgment.
Yes.
And then you would also like to be able to return to your maiden name of Mia Boyge.
Yes.
Those are all my questions of the petitioner, Your Honor.
Thank you. And do you have any questions for respondents?
I do, Your Honor. Mr. Castillo Salguero,
Yes.
you have heard the questions I asked of your wife.
Yes.
You have heard her answers.
Yes.
Is there anything she said that was not accurate?
No.
Okay. You understand that I am not your attorney,
Correct.
and you understand that I was not able to provide you with any legal advice as I was Mia's attorney.
Correct.
I have not provided you with any legal advice, correct?
Correct.
All right. You have also signed this marital settlement agreement, correct?
Yes.
All right. If I can once again put it up to the camera and show you, can you see your signature?
Yes.
And that was a signature by DocuSign, correct?
Correct.
You use that program to apply that signature to the
Yes.
document. And you did the applying of that signature,
Yes.
all right? And you intend for this electronic signature to have the same legal effect as if you had signed with a pen in your hand,
Yes.
right? You also initialed each page,
Correct.
and you did so with DocuSign.
Yes.
And you intend for those electronic initials to have the same legal effect as if you had initialed with a pen in your hand.
Yes.
All right. This means that you agree to this document in full.
Correct.
It also means that you have actually read the document.
Yes.
In fact, before you signed it, you asked us to make a change to the document, correct?
Correct.
And we did make that change.
Yes.
And then you signed after we made that change.
Correct.
You understand that this document, in this document, you are waiving maintenance from Mia.
Yes.
And you understand that that means that you cannot come back into this court or any court at any time in the future and ask for maintenance from Mia.
Correct.
All right. You understand all of the provisions of the document?
Yes.
You intend to live by those provisions?
Yes.
Do you know of any assets that are not specifically mentioned in this marital settlement agreement?
No.
All right. Do you believe it's an equitable division of your marital estate?
Yes.
And did you agree to it voluntarily?
Yes.
Those are all my questions, Your Honor.
Thank you. The court finds it has subject matter jurisdiction and personal jurisdiction over the parties. They were married on January 11th, 2019 in Maricopa County, Arizona. They've been separated for the appropriate amount of time. At least one of them lives in Lake County, Illinois for 90 days prior to filing the petition. No children were born or adopted to their relationship. Petitioner is not pregnant. Court finds it's been proven that irreconcilable differences have caused the irretrievable breakdown of the marriage. Efforts at reconciliation would be impracticable and not in the best interest of the family. Court finds the parties have entered into a written marital settlement agreement, which the court has reviewed. Court finds the property settlement is not unconscionable. The division of marital property and debt and non-marital property and debt. It's fair and equitable and memorialize the marital settlement agreement. Court finds the parties agreed to waive any claim of maintenance as to the other. That waiver is not unconscionable. Petitioner may, but is not required, to resume the use of her maiden name, spelled B-O-I-D-Y, if and when she so chooses. Folks, anything else before I finalize the divorce in this case?
No.
No.
And what I'm doing now is I'm signing the judgment for dissolution of marriage. This completes the process of divorce for each of you on the same terms that all of you worked out. The parties will receive a copy of this in the mail from the clerk. Good luck to all of you.
Thank you.
Thank you, Your Honor.
I know the next parties who are here are Les Nowitz, if I'm pronouncing that right, and Les Nowitz. And I know Ms. Lichter and Ms. Moran. And I also see Ms. Is that pronounced Lesnowitz?
It's
Lesnevich.
Lesnevich.
Lesnevich?
Yes.
Okay, thank you. We're
Sure.
at Lesnevich and Lesnevich. And I take it Stephen Lesnevich will not be present. Is that correct?
That is correct, Your Honor.
Thanks, Ms. Lichter. I've got the documents here in the case. Ms. Lesnevich, I'm going to ask that you please raise your right hand, ma'am. I'm going to ask you swear to tell the truth, the whole truth, and nothing but the truth.
I do.
Please lower your hand. And the court has the documents here. Ms. Moran, you are welcome to make a record and proceed with testimony from Ms. Lesnevich.
Thank you, Your Honor. Tracy, could you state your name and spell it for the record, please?
Tracy Lesnevich. The last name you want spelled?
Yes, please.
Lesniewicz.
And I'm just going to quickly make a record. This is in the marriage of Tracy and Stephen Lesnevich, 19D 786. Petitioner present with Ms. Mickey Moran representing her. Respondent is present through his attorney, Sally Lichter. We're here for prove up, and it's by Zoom. And Ms. Moran, you're welcome to proceed with testimony.
Thank you for that, Your Honor.
And Your Honor, I would just like to state that we would like to offer a stipulation as to the signatures being the signatures of the parties.
Oh, thank you. And is that correct, Ms. Moran?
Yes, that's correct, Your Honor.
And the court will accept that stipulation. You are welcome to proceed with testimony, ma'am.
Tracy, you've lived in and how old are you?
51.
And you were married to Stephen on August 27th, 1997, and that marriage was registered in Cook County.
Yes.
And irreconcilable differences have arisen between you and Stephen, such that it's not practical or in the best interest of your family to continue staying married, correct?
Yes.
And you and Stephen had 2 children, both now who are emancipated.
Yes.
You and Stephen also disclosed your financial affidavits to each other.
Yes.
And as a result of that, Stephen has agreed to pay maintenance in the amount of $1,200 per month, correct?
Yes.
You've also divided your debts and assets and shared them on a 50-50 basis.
Yes.
And you've had a chance to review this document, correct?
Yes.
And are you satisfied with the document?
Yes.
And you entered into this marital settlement agreement voluntarily, correct?
Yes.
And you're willing to live by its terms.
Yes.
And you're asking also to resume your maiden name of Louder if
Yes.
you choose.
Yes.
And are you asking this court to grant you a dissolution of marriage today?
Yes.
And are you agreeing, would you like the court to incorporate the marital settlement agreement into the judgment?
Yes.
Nothing further.
Thank you, Ms. Moran. Ms. Lichter, do you have any questions for petitioner?
No, Your Honor.
Thank you. The court finds it has subject matter jurisdiction and personal jurisdiction over the parties. They were married on August 30th, 1997 in Bridgeview, Cook County, Illinois. They've been separated for at least 6 months. At least one of them has lived in Lake County for 90 days prior to filing the petition. There's 2 children born to their relationship. Each of the children is emancipated. There's no minor children left in their relationship. Petitioner is not pregnant. The court finds it's been proven that irreconcilable differences have caused the irretrievable breakdown of the marriage, and efforts at reconciliation would be impracticable and not in the best interest of the family. The court finds the parties have agreed to have entered into a written marital settlement agreement, which the court has reviewed. The court finds the property settlement is not unconscionable. The division of marital property and debt and non-marital property and debt is fair and equitable, memorialized in the marital settlement agreement. The court finds the parties have agreed to maintenance terms in this case, and the husband shall pay the wife $1,200 a month. The exact terms and details of maintenance are stated in the agreement before the court and in a proposed judgment before the court. The court refers back to the parties' agreement for the details of the maintenance in this cause. And petitioner may, but is not required, to resume the use of her maiden name of Lauter, Lauter, if and when he so chooses. Folks, is there anything else before I finalize the divorce in this case?
No, Your Honor.
No, Your Honor.
And Ms. Lesnevich, I am now signing the agreed judgment of dissolution of marriage. This enters judgment on the same terms that you worked out with your attorney, and this will complete the process of divorce for you. The documents will be mailed to the respective parties.
Thank you, Your Honor.
Thank you.
Your
And
Honor,
thank you, folks.
take care. Bye-bye.
Bye.
And I think, okay, got it. And do we have the parties on Ferrioli and Gangi?
Yes.
Yes, Your Honor.
Okay, I see them going to, I see Mr. Gangi, and I'm asking him to please, okay, now at least we can hear from him. And Ms. Ferrioli and Mr. Gangi, I'm going to ask that you please raise your right hand. And do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Mr. Gangi?
Your Honor, I don't think he's present today.
Okay. And you might be right. I know I see a black box that says Joe Gangi on it right now on my screen. But that doesn't mean that I've heard him. So that's
Interesting.
That's why I was asking a question. Mr. Gangi, are you present?
Yeah.
There you go. And now I see you present. And Mr. Gangi, hello, sir. Mr. Gangi, can you hear me? Now, I can hear you, but, I mean, sorry, you can hear me, but possibly, but I know I can't hear you.
Mute my microphone. or turn on-
Mr. Gangi, can you hear me now?
It's over. There was one case they told me, and then they take me out. Maybe they only told me. Think it's done. You get me out? Or did they take me out?
Ms. Lesnevich, you're welcome to, you're welcome to move on with the rest of your day. Now, Mr. Gangi,
You know what, let me go check. Hang on a second, I can find out. Let me see if he's got a technical difficulty.
tell you what we're gonna do. We might go, okay, hold on. Now he's entered the waiting room, and let's see if we can do a little on this.
Hello?
Hello, sir.
Joe.
Can you hear me?
I can hear you. Sir, can you hear me?
Yes, I can.
Okay. And Mr. Gangi, I'm
It's
going to...
Ganji.
Ganji, thank you. Mr. Ganji, I'm going to ask you, please raise your right hand. And sir, I'm going to ask you, swear to tell the truth, the whole truth, and nothing but the truth.
Yes.
Thank you. Please lower your hand. And are the parties ready to proceed with judgment of dissolution?
Yes.
And Mr. Ganji, are you ready to proceed?
Yes.
Okay. Mr. Kelly, you are welcome to make a record and proceed with testimony.
Okay, Judge, thank you very much. Your Honor, James Kelly, this is in re the matter of Janine Farioli, that's Jeannine Farioli, spelled Farioli, versus Joseph Ganji, spelled Gangi, 20D589. Your Honor, the petitioner is Janine Farioli, so I would be asking some questions of her.
You are welcome to proceed with testimony.
Okay, Janine, would you please state your name for the record?
Sure. It's Janine Farioli.
And you are the petitioner in this cause of action, is that correct?
Yes.
And you've been a resident of the state of Illinois, County of Lake, for a period of 90 days prior to your filing of the petition for dissolution, is that correct?
Correct.
You were lawfully married to Joseph Ganji on October 12, 2002 in the state of Illinois.
Correct.
And you have 2 children born to the marriage, is that correct?
Yes.
You want to just state their names and dates of birth? Judge, do you want dates of birth or just ages?
Please, dates of birth.
Okay, if you would state their names and dates of birth.
Heather Ganji, December 14th, 2005, and then Catherine Ganji, March 22nd, 2008.
Okay. And is it true that irreconcilable differences have arisen throughout the course of this marriage?
Yes.
They've caused an irretrievable breakdown in the marriage.
Yes.
You've attempted to reconcile the marriage, but found your attempts to be fruitless. Is that correct?
Correct.
And you believe it's in the best interest of the parties that this marriage be dissolved?
Yes.
Okay. Now, you've had the opportunity to review and sign certain agreements. Is that correct?
Correct.
And so has Joe, correct?
Correct.
I'm going to first point to the marital settlement agreement, and I'm going to try and have you identify your signature and Joe's signature also.
Okay.
Can you, is that working? Can you see that?
Yes. I can see both the signatures. Correct.
Do you recognize your signature?
Yes.
And the signature of your husband?
Yes.
Okay. That's page 16 of the marital settlement agreement. You understand?
Yes.
And you understand that the marital settlement agreement settles all the issues as between you and your husband, correct?
Correct.
In this agreement, you're waiving maintenance, formerly known as alimony. That's your right to receive support from your husband. You understand that?
Correct.
You do that freely and voluntarily. You understand that you cannot come back to this court or any other court in the future to receive it. Is that correct?
Yes.
In fact, this is a mutual waiver of maintenance, which means Joe's waiving maintenance too. Is that correct?
Correct.
Okay. And in this agreement, we're going to be setting up a 503G child support trust for the payment of child support. Is that correct?
Correct.
Which will be funded from the 401k. Is that correct?
Correct.
Okay. And you understand that the real estate that you currently own is at 830 West Golf Road, Libertyville, Illinois. Is that correct?
Yes.
And both you and Joe are currently residing there. Is that correct?
Correct.
Okay. And you understand the provisions in the agreement regarding the real estate and how the real estate will be handled. Is that correct?
Correct.
Okay. You will be dividing your 401k in the manner provided in this agreement. Is that correct with Joe?
Correct.
Okay. You are not forced or coerced into entering into this agreement. Is that correct?
Correct.
It's a product of your own free will.
Correct.
Okay. And there were no other children born to this marriage other than the 2 children you mentioned. Is that correct?
Correct.
You're not presently pregnant. Is that correct?
Correct.
Okay. And then speaking of the children, we also have an allocation judgment. Is that correct?
Yes.
And the allocation judgment deals with all of the parental responsibilities and contains within it the parenting plan for the minor children. Is that correct?
Yes.
And I'm going to, again, see if you can identify the signatures on the last page of the allocation judgment. Do you see this? Do you recognize your signature?
Yes, I do.
And the signature of your husband?
Yes.
Okay. Now, in this agreement, this takes care of any and all issues that surround the minor children. Is that correct?
Right. Mm-hmm.
You understand that you and Joe will be making joint decisions regarding their health, education, religion, and extracurricular activities, is that correct?
Yes,
With the parenting time set forth in this agreement.
yes,
And in fact, you're doing a nesting of sorts, a nesting birds arrangement, is that correct?
correct.
And that's set forth in this agreement.
Yes,
You believe that you're a proper and fit parent to have the type of parenting that is put forth in this agreement?
yes,
You believe Joe, your husband, is also a proper and fit parent to have those responsibilities?
yes,
You believe that it's in the best interest of the children that the parenting arrangement set forth in this agreement be imposed upon you and Joe, is that correct?
yes,
And the children will be better off for it, is that correct?
correct.
Once again, no one has forced or coerced you into entering into this agreement or the marital settlement agreement. Is that correct? And you're not under any type of debilitation. You weren't under any type of debilitation at the time you signed this agreement that would in any way hinder your ability to understand it. Is that correct?
Correct.
And you're already using your maiden name. Is that correct? Farioli?
Correct. I never,
Okay.
yeah,
So we don't need to worry about changing your maiden name. Is that back to your maiden name? Is that correct?
right, right. Mhm.
Okay. Judge, I have no further questions of this witness.
Thank you. And do you have any questions for Mr. Ganji?
I could just ask him some general questions, Judge, about the testimony elicited from Ms. Farioli.
You're welcome to.
Thank you, Judge. Mr. Ganji, hi there. How you doing?
Mhm. Yes,
Very good. Were you able to hear the questions that I asked of your wife?
yes,
If I were to ask you the same questions, would your answers be the same?
mostly.
Okay. What is there anything specifically that you wouldn't agree to?
I think I'll just make this simple and just say, yes, I agree with what she said. Instead
Okay.
of,
That's fine. Okay. And you signed these agreements, is that correct?
yes,
And you were able to see the signatures that I put up to the screen, is that correct?
correct,
And you recognize your signature, is that correct?
correct,
And in the marital settlement agreement, you're waiving maintenance, formerly known as alimony. That's your right to receive support from your wife. You understand that?
yes,
Back to this court or any other court in the future to receive it. You understand that?
yes,
Okay. And you believe you're a proper and fit parent to have the parenting time as set forth in the allocation judgment. Is that correct?
yes.
Okay. I have no further questions, Judge.
Thank you. Anything else from any of the parties?
Nope.
And the court finds it has subject matter jurisdiction and personal jurisdiction over the parties. They were married on October 12th, 2002 in the state of Illinois. They've been separated for at least 6 months. At least one of them has lived in Lake County for 90 days prior to filing the petition. 2 children were born to their relationship. H.G. born December 14, 2005. K.G. born March 22, 2008. No other children born or adopted to their relationship. Petitioner is not pregnant. The court finds it's been proven. The court finds it has jurisdiction under the Uniform Child Custody Jurisdiction and Enforcement Act. The court finds it's been proven that irreconcilable differences have caused the irretrievable breakdown of the marriage, and efforts at reconciliation would be impracticable and not in the best interest of the family. Court finds that parties have entered into a written marital settlement agreement, which the court has reviewed. Court finds the property settlement is not unconscionable. The division of marital property and debt and non-marital property and debt is fair and equitable, memorialized in the marital settlement agreement. Court finds the parties have agreed to waive any claim of maintenance as to the other. That waiver is not unconscionable. Court finds the parties have entered into a parenting plan which serves the best interests of the children after considering all required statutory factors. That parenting plan contains dispute resolution provisions and review provisions. The court finds the parents will be able to cooperate in carrying out their significant decision-making responsibilities in the children's best interest after considering all required statutory factors. Court finds the parents The parenting time arrangements of the parties serves the best interests of the minor children, after considering all required statutory factors. The court understands that by agreement, child support is reserved at this point. The court understands that there is a nesting arrangement by the parties for that and other reasons. The parties have agreed to reserve child support. The court accepts that agreement. From either of the parties, anything else before the court finalizes the divorce in this case?
Nope.
No.
Mr. Ganji, then the court will in fact be entering judgment of dissolution of marriage. And what that does is it finalizes the divorce on the terms that all of you have worked out. This will complete the process of divorce for you. The clerk will send a copy of the documents back to the parties. Good luck to each of you.
Thank you.
Thanks, Your Honor.
Goodbye.
Thank you.
Bye-bye.
Bye. And I now have, hello, Ms. Schiffman. I know we've got the Rickards here, and they're both at, looks like the law library. Good morning, Mr. Rickert, and good morning, Ms. Rickert.
Good morning.
And the court has the documents on this. And
So Judge, this is different than the other documents you've heard this morning. The Rickards came, Miss Rickard is my client. She came to me after her and her husband had been through mediation, and there's a memorandum of understanding attached to the wraparound judgment that they negotiated themselves.
okay, got it. Now, do I have this right? The memorandum of understanding is dated February 10th, 2019?
I questioned that, and it is in fact dated February 10th, but it was done in 2020.
Got it. Okay. Then at least I'm just going to put down 2020 and put my initials next to that year. Got it.
Terrific.
Mr. and Ms. Rickert, I'm going to ask that each of you please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
And Ms. Rickert?
Yes, Your Honor.
Thank you. Please lower your hand, folks. And Ms. Schiffman, you are welcome to make a record and proceed with testimony.
Thank you, Judge. Judge, this is in re the marriage of Christine, Kristine Rickert, Rickert, and Brandon, conventional spelling, Rickert, 20D409. I'm Rena Schiffman. I represent Christine Rickert. Mr. Rickert was part of the mediation and negotiations, and has given his input into this as well.
Thank you. The court has the necessary documents. You are welcome to proceed with testimony.
Okay, I'd like to call Christine Rickert and have her testify.
You may.
Ms. Rickert, can you hear me?
Yes.
Okay, terrific. Christine, have you been a resident of Lake County for 90 days prior to you filing this petition?
Yes, I have.
And were you married to Brandon on December 18th, 1999 in Fort Wayne, Allen County, Indiana?
Yes, that's correct.
And did you have two children, Addison, born March 11th, 2008, and Cameron, born April 20th, 2010?
Yes.
And you are not now pregnant?
No.
And you are telling the judge that irreconcilable differences have caused an irretrievable breakdown of your marriage?
Correct.
And you
Yes.
you tried to reconcile and it didn't work, and you believe that if you tried again, it would also be unsuccessful?
Yes.
And Brandon works for Snap-on Credit, and you work as a teacher at Daniel Wright Junior High.
Yes.
And you and Brandon mediated the terms of the memorandum of understanding with Brian James. Is that correct?
That is correct.
And after you came to me, I pointed out a couple of additional things, and those additional things were by agreement written into your memorandum of understanding, correct?
That is correct.
Okay, and I'm just going to go over some of the highlights of this. On page 3 of your allocation judgment, you and Brandon have agreed to joint parenting. It
Correct.
says co-parent, it says joint parenting statement, but it's really co-parenting, correct?
That is correct.
And you're going to share the responsibilities of all parents with the sole exception of education. You have the sole decision regarding education, correct?
That is correct.
And when we met, you and I discussed whether or not I thought that you and Brandon could work together to co-parent these children. And you said, absolutely.
That is correct.
Okay. And the children, for the purposes of school, are going to reside with you, correct?
Correct.
And you've worked out a parenting time with holiday visitation included, and this was all negotiated with Brian, and it reads exactly the way you wanted it to read, correct?
That is correct.
Okay. And so you're buying Brandon out of the marital home, correct?
That is correct.
And you've agreed to a time that he's going to buy you out, and you're going to buy him out, and the terms for that already, correct?
Correct.
But it has not yet occurred.
Correct.
Okay. You're each going to keep your own car. You're each going to keep your own personal property, and your money has already been retired. Your bank accounts have already been divided.
Correct.
And you have retirement benefits, and those are going to be utilized partially for the buyout, correct?
Correct.
Okay. And the marital portion of your TRS is going to be divided by a quildro, and the marital portion of Brandon's pension is going to be divided by a quadro, and you're going to receive a little bit less because you're buying him out of the house, correct?
Yes.
Okay. And the quildro and quadro, you've asked me not to prepare those, correct?
Correct.
Okay. But you understand that has to be done, or it can't be, or that you will not, the accounts will not be divided.
That is correct.
Okay. And you've divided the marital debt?
Correct.
Okay. And for child support, Brandon is going to pay you directly.
Yes.
And I explained to you that there's a state disbursement unit, and I recommended that you went through that, and you and Brandon have elected to go separately.
Correct.
Okay. And you're going to exchange documents, correct?
Correct.
Annually?
Correct.
Okay. And you each understand, you each have life insurance policies. You understand that you have an obligation to maintain those life insurance policies.
Yes.
Okay. And you're going to share education and daycare costs, 60% you, 40% Brandon, correct?
Correct.
And Brandon has the children's health insurance, and he understands that that's his obligation.
Yes.
And medical expenses are also going to be divided 60% you, 40% Brandon.
Correct.
Okay. And and you've also asked that you told me, and you're telling the judge, that you don't need maintenance from Brandon. You can support yourself without any contribution from him.
Yes.
And it's your understanding that Brandon also can support himself without any contribution from you.
Yes.
Okay. And does this agreement, the memorandum of understanding and the wraparound judgment, does this encompass your entire agreement with Brandon?
Yes.
I have nothing further of this witness at the time, Judge.
Thank you. Do you have any questions for a respondent?
I do, just a few.
You may.
Mr. Rickert, have you reviewed this judgment and memorandum of understanding that was prepared by Brian James?
Yes, I have.
And to the best of your knowledge, is this the agreement that you and Christine negotiated?
Yes, it is.
And you read it and you approve of it?
Yes, I do.
And you understand that you're telling the court that you do not need maintenance from Christine. You can support yourself without any contribution from her.
That is correct.
You understand you can't come back to this court or any other court and ask for Christine to help support you.
I understand. Yes.
And you understand that you paying Christine child support directly rather than have it go through the state disbursement unit.
That is correct.
And you understand that I did not represent you. I represented Christine.
I understand, yes.
And you understand that you and Christine have elected to go someplace else to get the documents drafted to divide the pensions.
Yes, that is correct.
Okay, I have nothing further of this witness, Judge.
Thank you. The court finds it has subject matter jurisdiction and personal jurisdiction over the parties. They were married on December 18th, 1999 in Kern County, Indiana. They've been separated for at least 6 months. At least one of them has lived in Lake County for 90 days before filing the petition. 2 children were born to their relationship. Initials AR born March 11, 2008, CR born April 20, 2010. No other children born or adopted to their relationship. Petitioner is not pregnant. The court finds it has jurisdiction under the Uniform Child Custody Jurisdiction and Enforcement Act. Court finds it's been proven that irreconcilable differences have caused the irretrievable breakdown of the marriage, and efforts at reconciliation would be impracticable and not in the best interest of the family. Court finds the parties have entered into a written marital settlement agreement, which the court has reviewed. Court finds the property settlement is not unconscionable, and the division of marital property and debt and non-marital property and debt is fair and equitable and memorialized in the marital settlement agreement. Court finds the parties have agreed to waive any claim of maintenance as to the other. That waiver is not unconscionable. Court finds the parenting plan of the parties serves the best interests of the minor children after considering all required statutory factors. That parenting plan contains the necessary dispute resolution provisions and review provisions. Court finds the parents will be able to cooperate in carrying out their significant decision-making responsibilities in the children's best interest after considering all required statutory factors. Court finds the parenting time arrangements of the parties serves the best interests of the minor children after considering all required statutory factors. Child support agreed upon by the parties is acceptable to the court, and respondent shall pay petitioner $500 a month for child support. The court accepts the agreement. Anything else? And was there anything about petitioner asking for the right but not the obligation to resume the use of her maiden name?
There was not. Ms. Rickard and I discussed that, and she said because her children are young, she intends to keep the name Rickard. But certainly if she wants to change it, I have no problem with asking you to add that provision.
No, I'll keep my name.
And the court will leave that alone. Anything else before the court enters judgment of dissolution in this cause?
Not that I can think of.
Okay, what I'm doing, folks, is the court is entering judgment for dissolution of marriage, and this completes the process of divorce for each of you. The clerk will mail a copy of these documents to you. My best wishes to each of you.
Thank you.
Thank you very much, Judge. Stay safe.
You too. One moment, please, folks. Yeah. Oh, sure. Let me see where it is. When's the last time I used it?
I'm gonna keep looking for it, Jim.
Please do.
If you find it, would you mind just popping it?
I will. Thanks. Okay. And thanks, Ms. Schiffman. You're welcome to just hit end meeting or whatever that is.
Thank you, Judge. Have a nice day.
You too.
Stay safe.